Good afternoon. It's about 12:01. Welcome to the Appellate Division First Department. As I call the calendar today, please ask for the time you actually need. And remember, if the panel has additional questions past the time you have been allotted, we'll ask those questions and you'll have an opportunity to answer. We read your papers and are familiar with the issues that underlie your appeal. I know both of you are, this is not your first time here, but you should know that when the white light goes on the lectern, then you have 2 minutes left. So when I call your case, let me know how much time you are requesting. The first case to be heard this afternoon will be Coleman versus Board of Elections, which is actually two appeals, and we'll hear those two cases in tandem. Would you like some rebuttal time, Mr. Schwartz? You want to go 8 and 2, for example? Mr. Newell? Okay, I'll do 8 and 2 and 7. Okay, and on Baez? Next case up? There's some overlap in the issues, so perhaps I'll give you a little less. 6 and 2 and 4? Very good. Okay, first case, Coleman.
Your Honors, this...
Are you starting, Mr. Schwartz? Should I start the clock?
Good afternoon. This...
Could you make your appearance, please?
Oh, sorry. Arthur Schwartz, Advocates for Justice, Chartered Attorneys for Appellant Zandria Coleman. This case involves a candidate for a Democratic district leader on the Upper East Side. She filed 900 signed petitions. She had some of her signatures disqualified. The one that we took offense to was where a witness put down his address, which was a Queens address.
We're getting to the merits. We should probably start with the threshold issue about the verification.
Okay. So and I'm not sure if the court had time to see my reply brief, but the verification in this case, as I set forth the whole thing on page 6 of my brief, it was with a jurat, and it said, verification affirmation, Arthur Schwartz being duly sworn, says as follows: he is attorney for petitioner. Within the proceeding, he has read the foregoing petition and knows the contents thereof, and the same are true to petitioner's own knowledge.
Right, we're aware of the typo.
Clearly, yeah. And we discussed this at the bench when we were arguing it that day. It was clearly, every other word in there was me, I.
And male pronouns as well.
Records.
The male pronouns help differentiate you from the petitioner, too.
I didn't hear what
Well, using he and him, I mean, the petitioner, Ms. Coleman, is a Ms.
Right.
So that's another way of differentiating. But Mr. Newell makes the point that he objected timely to the verification. And then you counter that by saying, well, you didn't talk about this particular error. You just sort of generally spoke about the verification.
No, he didn't do that.
He didn't? Okay, so you disagree that he disputed anything about the verification?
Well, the record below, Mr. Newell, by the time I served him at home, by the time I got to my car, he had already emailed me his rejection of the papers. So he had rejected them, but the grounds that he rejected them on was that I was an attorney in the same county as the petitioner and therefore didn't have a right to verify as an attorney. And I literally texted him back and told him to look at the last phrase in 3023, which says unless the attorney has knowledge of all the facts in the petition.
But that is still an objection to the verification.
It was an
You
objection
concede
to
that.
right. It was an objection to the verification, but it wasn't addressed to the words. The judge picked that out when we were in court that morning, which I believe was the morning after that. I got Mr. Newell's papers, which only talked about his answer. Only talked about the fact that I wasn't an attorney in the same county. I was an attorney in the same county as the petitioner. When we stood in front of the Judge Billings, and so this issue of my use of the word petitioner by accident hit me in the face, right, and early in the morning, and I said to her, clearly that's a typographical error, and I'm here. And there is a case that addresses this that I discussed in my reply brief, which is at least on the record. The case is, forgive me, Tenerello versus Board of Elections, 104 AD 2nd 467, where the Second Department, in a very similar situation, reversed the Supreme Court and said the attorney was there. You could have had a hearing on the issue. It was a verification dispute that the parties were having, and that the court didn't do that. The court just had me. I argued. I said, Judge, it was clearly an error, cut and paste from another verification. But it was he, him, his, my, except one word petitioner on there. And then I believe we didn't get into the merits. That was the only thing we discussed.
So here's my concern. 3022 of the CPLR is so up and down. It's so black and white, where it says that a defectively verified pleading shall be treated as an unverified pleading, and it may be treated as a nullity. So that's problematic. And there's case law that says that if it's not properly verified, there is no jurisdiction, and it cannot be amended. Period. End of story. And there's a couple of Second Department cases. Daniel Frieza. There's two cases under that name, one from 2002, both from 2002, excuse me. And then there's a 2010 case, a matter of Niebauer, that says that such a defect is jurisdictional in nature and cannot be cured by amendment. When I read the verification, I looked at it several times because I said, what is this saying, particularly given the punctuation? As you know, we look at punctuation all the time in order to discern the actual meaning of a writing. And here I said, so is this referring to records in his possession, referring to the attorney, you, who's doing the verification? Is it referring to the petitioner, who would be a her? There's a comma. So are you verifying to what the petitioner knows, which would be hearsay? And I couldn't figure it out. The more I looked at it, the more problematic I found it, I'm sorry to say.
Well, Your Honor, if you did, first of all, so our argument is it wasn't not verified, that there was an error in the verification that puts it on that was it or wasn't fall into 3022. Because even if you do the analysis you did with the commas, if you took out "are true to petitioner's own knowledge," and it says, but it talks about his records, his belief, his own knowledge, his records in his possession, as to matters as to matters stated on information belief, he believes it to be true.
Yes, but
The
the problem,
sentence would not make sense with the word petitioner in it, and it was a typographical error. It was not a. It was an effort doing these quickly. You have very little time.
I'm going to give you more time, Mr. Schwartz. Don't worry.
Right. And I wanted to get then we got the decision from Judge Billings on Monday the 1st.
Mr. Schwartz, I'm going to give you 2 more minutes, additional minutes, so you'll want to talk about the service as well as
Right. So in
merits, too.
in the second case, the Judge Billings signed an order to show cause late between 1 and 2 o'clock in the afternoon. Said it was returnable the next morning at 10 o'clock. Had to be served by midnight that day, even though the statute of limitations didn't end until the next day at midnight. And I wrote a letter saying, can't we get another 24 hours? And her clerk said, no, the judge has another calendar on Thursday.
Well, it was late in the day. I mean, can't we understand the judge to have just wanting to make sure that she was able to get a decision out? Because the appeal came a little bit, your
I'm
article
telling
said-
you what the clerk said to me. She has a calendar on Thursday. And because she then had more hearings on Friday. So I met the client. I gave it to her and her server up on the Upper East Side. They put it on the door of they returned several times. They taped it to the
do
door.
we have an affidavit of service here?
But okay, so what you had was, I got a call, so I had to do this by the morning. I put in an affirmation from me explaining what the client's server had done, plus when
You
I got,
explained what the server had done?
because how do I get an affidavit from someone on the Upper East Side and file it before 9 o'clock in the morning when I had to be in court? It was not, it was an impossible situation. So I explained it.
Subsequently provided an affidavit of service at the hearing?
No, the client was there. She was there. The server was there. No, there was no effort to have a hearing. She was sitting in the audience trying to get the attention. I wasn't. I was in contract negotiations at the Transit Authority. My associate was there, and
Sorry, there in the courtroom?
yes, she was in the courtroom. Ms. Coleman and her server were in the courtroom, and the judge, and it was represented they were left in a pile in the lobby, which was not what I had said in my affirmation, plus that I had mailed it, plus that I had emailed it to the people, plus that I had emailed it to Mr. Newell, who in the prior case was the recipient of
If the process server
service.
was there in the courtroom, did you do an affidavit of, an affidavit of service right then and there?
No, we didn't do an affidavit of service right then and there. I was otherwise engaged and sent an associate with my affirmation to say, we represented this to the court last night at midnight and or after midnight, that this is true, that someone had nailed and mailed it to the door. There was clearly no, and mailed it and emailed it because on their objections they put their email address and emailed it to their lawyer. There was, when you look at
Affirmation,
308,
I believe, referenced the second attempt at service. Did it say anything about the first attempt at service?
it said they
This was mail and
visited.
mail.
Your Honor, we're talking about the judge gave us a total of 10 hours.
No, but I'm asking you, did you also indicate how the first attempt of service was made?
I'm looking at my brief because I don't remember what it said.
Maybe I missed it.
Mr. Schwartz, you can come up with that
Okay.
in rebuttal.
Thank you.
Newell? So just for symmetry's sake, why don't you start with verification, then talk about service, and then perhaps you should talk a bit about the merits, even though Mr. Schwartz hasn't been able to yet.
Thank you, Your Honors. May it please the Court, Paul Newell for Respondents Solomon and Jimperson.
Mr. Newell, before you begin, on verification, I just want to ask you, when you reject a pleading for improper verification, are you required to specifically pinpoint what is defective with the verification?
Yes, and we did, Your Honor. Well, we'll dive right into that. First of all, appellant's claim that the issue was not raised is false. Being out of county was only one of the issues raised in both the email notifying counsel and in the answer. The email said specifically, quote, specifically, I will note that you purportedly attorney verified the verified petition.
Talking
What?
too fast.
Sorry, apologies. The verified petition, while being located in the same county as the petitioner, and express no other reason for such purported attorney verification as required by the CPLR. Specifically, CPLR 3021, the affidavit of verification, blah, blah, blah. If it is made by a person other than the party, he must set forth in the affidavit the grounds of his belief as to all matters not stated upon his knowledge and the reason why it is not made by a party. He did not do so. He claimed to, the affidavit on its face claims to be on petitioner's knowledge, which Mr. Schwartz is incompetent to attest to. That was raised specifically in the email. The answer at paragraph 29, attorney for petitioner Arthur Z. Schwartz provides no explanation in his purported verification as to why he used attorney verification instead of party verification as required by the election law and CPLR. So it was raised with particularity, and they're somewhat the same issue. The case that counsel relies upon, Teneriello, is inapposite, in fact, even argues for respondent's position. There, the attorney did affirm upon my own knowledge, or the attorney's own knowledge, but it was, and the trial court rejected that. The Second Department and then Court of Appeals affirmed because, as he said, they should have had a hearing on why. But the Court of Appeals said the reason why was not a lack of a hearing, but rather because there was a reason. Namely, the reason was that he was out of county, that the attorney in that matter was not in the same county as the appellant or the petitioner. So there were reasons there. Those reasons are not present here. All the parties were in the same county, and CPLR 3021 requires him to give a reason as to why he's attesting to his own knowledge, and furthermore, he attested to someone else's knowledge, which he cannot do. So,
Would you turn to the service issue?
the service issue on matter two. So first, I would note there's also a service issue on the appellate level, and that the board counsel is not here, but board was not served with the notice of appeal. And there's no subpoenas of records, nothing on that. So I would note that there's a real
The
jurisdiction.
Board of Elections is submitting on that issue. You don't have to carry their water for that.
So regarding the service, Mr. Schwartz is incorrect when he says there was an affirmation filed describing even an affirmation describing the actions of another person, which would obviously not be valid. But the only affirmation or affidavit filed in this matter prior to the return date was what I call in my answer the time machine affidavit, affirmation, which said, it's NICEF document number 12. Mr. Schwartz affirms that he is the attorney for the petitioner within proceeding, and that on April 24th, 2023, I did personally serve a copy of the order to show cause and no supporting papers on the Board of Elections, and to Paul Newell, me, respondent's attorney, at 10 p.m. at 65 Columbia Street. He gets the apartment wrong, dated April 25th. Now, this matter was filed on May 2nd. The order was signed on May 2nd. Obviously, we are not suggesting this is an attempt to mislead the court. Clearly, this was filed in error. We're not suggesting anything, but equally clearly, it cannot be accepted as proof of service of an order signed on May 2nd.
You make that point in your brief very well. Can you turn to the merits just for a minute? Because I gather that a major reason that the petitions were rejected in part was that Stanley Morris was a subscribing witness on 12 designated petition pages. And he lives on Nurge Avenue, N-U-R-G-E, in Queens. And he didn't cross out New York, New York on the petition pages. But, you know, if you do a quick internet search, which we're allowed to do, the only NERJ avenue that exists in the city of New York is in Queens. And if the purpose of finding the person who subscribes the petitions is, you know, that you need to be able to find them in case there's an issue, I mean, really, is there an issue? On the so we're talking about the merits now. Is this really a reason to ding someone's petitions?
So both my respondents and the Board of Elections say yes, there is an issue, and as does the case law. If you look at Frome v. Board of Elections, cited in one of my briefs, 57 New York 2nd, 741, 1982. There's a couple of cases that it cites. Correctly listing the city or town is a defect that requires dismissing. Now, there is some case law that where if you leave out the town in the address line, but have it correct in the county.
Of course, we're talking about boroughs here. You didn't have any case law involving boroughs and mistaken boroughs. We're all part of New York City.
We are part of New York City, but we are not part of New York, all of us. This misstated the address of the witness. The Board of Elections, in their wisdom, found so. Furthermore, the court doesn't have jurisdiction to dispute it.
Well, but other than a prophylactic function and encouraging very pristine paperwork for proceedings that are on a very tight time frame, what is Justice Moulton was discussing, what would the prejudice be here if there was only one street of that name in the entire city of New York?
Well, the prejudice is that these documents are to be filled out according to the statute, and that's the designation of city or town in the statement of a witness to a designating petition is a matter of the legislatively mandated content of the petition, i.e., a substance and not a form. It follows then that the omission to include the prescribed information is fatal. That's from Frome, which I cited earlier. So,
Thank you, Mr. Newell.
thank you.
I gave you some extra time, too. I hope that was enough.
Your Honor, in answer to your question, and I'd have to check and see if I uploaded the wrong affidavit, but the one that I quoted from in my brief says, on the evening of May 2nd, the order to show cause was served on Hilda Solomon as follows. The server went to the door of her apartment 2 times. It was 10 p.m. on the second attempt. The server then taped a copy of the papers to Mrs. Solomon's apartment door. I mean, the same thing, it does say 2 times, which I think is the sufficient diligence under 308 to then do nail and mail. I don't have the whole file in front of me, so I can't tell you whether I uploaded the wrong affidavit or not. But the parties were in the courtroom in the morning, and the judge could have. There was a dispute. Counsel was saying no, it was nailed and mailed, and they were saying no, it was left in a pile in the lobby, which was, I don't know where they got that from because it wasn't true. I had photographs of the papers taped to the door. On the last issue, the courts have, the legislature several times in the election law and in the State Board of Election in their rules talk about substantial compliance and whether you put New York, you could cross out the New York or not when you actually put the address of the person and it's findable I believe, it's not one of those strict compliance things that you need to do in a petition. The board, on the notice of appeal question, the board was served with a notice of appeal. The board was served by email with the notice of appeal, and then we
Mr. Schwartz, do we know, say we did reinstate Mr. Sanders' petitions, does that get your client over the finish line for sure?
The board would have to look at those 17. She was 19 short.
I thought it was 25 short, but anyway, I mean, he had more than 25 names on his
79.
petitions, but were there other issues that were noticed by the Board of Elections with respect?
There were others, but we focused on that because his was 79. You could see that number in their report, that the witness was no proper address for the witness. So there was 79, so the board would have to go back and find 25 good ones out of those 79. In terms of the notice of appeal, as I said, the board did not file a notice of appearance I think I talk about that in the reply I filed. They did not file a notice of appearance in the lower court at all, zero. They didn't file any papers. And so what we did, and in fact, I do election law every year, the last lawyer that I dealt with at the Corp Council and said, I have 3 cases, do you, can I serve them on you? He said, I have nothing to do with this. So I emailed it to the general counsel of the board. And then what was interesting is that after I had an argument yesterday, same issue,
They consent to e-filing?
I only know now that they didn't consent to
Department of
e-filing.
Education.
They
mean, the Board
e-filed
of
here.
Elections, excuse me.
They e-filed here, as far as I know. They didn't deliver the briefs to their brief to the clerk's office. They did upload it. But they didn't appear. But so then I have now served them again. And you know how you serve them? By email. Because they only have intake for 2 hours on Tuesday and Thursday live. Otherwise, you get a note that says email in. So they were emailed service at corporation counsel at nyc.gov, something like that. They were emailed. The board general counsel was emailed the notice of appeal because I did not have an attorney to direct it to except her, who I do deal with all the time. And that was done. So I don't think there was any problem with the board getting notice. There were efforts made to figure out who it was. I say that in my
Thank you,
brief,
Mr.
and then
Schwartz.
they allow email service anyway.
Why don't we move on to the next appeal? Take a few minutes to gather your notes.
This this case is somewhat different, although it involves a verification. I think that's the only issue that this turned on. Here, the verification did not include the words under penalty of perjury. I think that was the whole issue.
Well, the court below found that we need to know that someone is ascribing and swearing to the facts contained in the petition, and it appears that that was not done here.
So first, let's talk about what's in the petition. The petition said, attached are the designating petitions filed by the other side. Attached are the objections filed by the other side. Attached are the clerk's reports in response to the objections filed by us. That's all it said. And it said the board rejected the objections because of some problem they had with service, where my clients had actually overnight mailed to 39 people packages of objections. And so that was, it wasn't even an issue of whether or not these people had enough signatures. It was whether, well, we got to challenge it from the start because we were still within the 14-day period to challenge, to invalidate if a candidate running against a candidate was challenging. So we were not per se appealing the board's decision. I believe that we were actually in court before the board made its final ruling on this. But the verification simply was, this is what's in the docket, this is what's in the docket, this is what's in the docket. That's all it said. And there was no fact in the entire petition that had to do, that came from anyone's knowledge other than attached to the objections, which went line by line through the petitions that the respondents had filed, and then attached is the clerk's report showing deficiency in each one of these.
Mr. Schwartz, do you dispute that the respondents timely notified you about the verification?
No, I think it was the same. I handed them all three at the same time, and I got one text back. I don't think again. Mr. Newell didn't pick out the issue that Judge picked out, which was under penalty of perjury, because otherwise, in this one, I did say I didn't make that petitioner mistake, but I didn't put under penalty of perjury. I do think that and I think we cite case law that the court could, particularly again since I was in the courtroom, besides the fact that Mr. Newell didn't raise that issue, all he said was, you can't verify this. You didn't explain why you're verifying this, even though it was plainly apparent from the face of the papers that all I was doing was reciting what was in the record at the Board of Elections.
But does that gut CPLR 3022, though?
Does it?
In other words, 3022 gives the other side the right to treat the petition as a nullity. And
But
they did
actually,
that.
Sorry.
And they did that. And so, isn't this an end around 3022?
Well, I cited a case from Judge Acosta when he was in the Supreme Court, where he said if it isn't specifically raised, it's waived. So even though they said this is bad, we're not accepting the
They
papers.
needed to be more specific, as you're
I
arguing.
think that then you could basically throw, and I know because we had a back and forth that night, Mr. Newell and I have known each other for 20 years, that the issue he was raising was that I was the verifier and not one of the petitioners. And I think that's the only issue that's why Judge Billings dismissed it, and we think we've argued basically that it was waived because it wasn't specifically raised. In fact, when we got the decision, I was somewhat flabbergasted.
Thank you. You may start, Mr. Newell. Please.
Good afternoon, Paul Newell for responding candidates. First of all, the difference that Mr. Schwartz points out actually goes straight to the point. This petition was entirely unverified. That is the meaning of verification, is to be sworn under penalty of perjury, and it left that out entirely. Thus, in the answer, where we noted at, I think it's at paragraph 20, this proceeding must be dismissed in that the petition was not verified in accordance with section 16.116 of the election law. That is because in this case, the issue, and we had obviously duly notified that we were rejecting the first sentence of the email sent to him is for failure to verify, and this is an unverified document. If it is not sworn, it is not a verification. Full stop. It's not a faulty verification. It's just not a verification at all. So he was notified. Again, the same thing in Chapter 29 and the CPLR we've gone through. I would note again Goodman v. Hayduck and the following cases, some of which Your Honor cited, saying that this is a jurisdictional matter. I would also note that all of these matters were dismissed without prejudice. In all three of these matters, I know we're only talking about one now, without prejudice. And in fact, in all three of the matters, counsel did file again. Now, albeit with other jurisdictional defects, but that is not the problem of the court. So this idea that this is such a harsh dismissal, he used the wrong word. This is not a typo, by the way, using the wrong word, but it's not a misstrike of the finger. These were dismissed without prejudice, and appellants were able to file again in all three of these matters and did so. the idea that this is some cold, harsh penalty is not true. I'd also like to just briefly mention, and we briefed it out, we don't believe the service as ordered in this matter, and the order to show cause was reasonably calculated to provide notice to 39 respondents who had not retained me, who I had not consented to the matter. Yes, I represented them at the Board of Elections. I did that for years before I was an attorney. I became an attorney last year. Your Honor said it was not our first time. My first time was yesterday. I didn't even get to be here for swearing in because it was COVID. But he came to my door at 10 p.m. on a matter with 39 respondents, some of whom I have literally never met and don't have their phone numbers, and expects me to calls that reasonably calculated to notify all of those respondents between 10 p.m. and midnight on a Monday. Next, I'd just like to go briefly into the standing issue. The petitioners in this matter do not have standing. Certainly with regard to the district leader race of Ron Thomas, I think that's very clear. There is nobody running against Ron Thomas. Ms. Paez is also running for Assembly District Leader, designated female. Mr. Thomas is designated male. There was one other person who designated as male. First of all, he would not be running against Ms. Paez functionally. And second of all, he is no longer on the ballot and not a party to this matter, so cannot provide standing there. For the rest of them, there was no particularity pled as to why they are aggrieved candidates. There is no grievance listed. Ms. Paez has no grievance even if it was listed. The other candidates, there is no grievance listed. I'm running election district 27.
Thank you, Mr. Newell.
Thank you.
Okay, before we go, I just wanted to return to Coleman briefly. I'm not going to, oh, you have some rebuttal time as well. Please.
First, I did cite case on page 7 and 8, two cases where it says if the verification does not comply with the specific mandates of 3021, the courts have disregarded insubstantial defects where the objecting party has failed to show prejudice. That's like decision. There was one out of Albany County. There was a similar decision in the third department, Harder versus Kuhn. And when Mr. Newell says it wasn't prejudicial, it was because the judge issued the decision May 1st. She issued the decision May 1st, and my clients didn't have a second shot at this because there's another period for people who are validating but not invalidating, which Mr. Newell actually educated me on. So this dismissal was it. Once it was dismissed, they couldn't come back and try it again. So there was a substantial prejudice to my clients, and no prejudice the defect that wasn't pointed out. And when Mr. Newell says he recites as an affirmative defense, the verification was not proper under 3021, 3022, whichever he cited. I don't think that's a specific objection that puts anyone on notice that as to what's talking about. Because in fact, when the argument went on in this particular case, it was on a Wednesday. The statute of limitations ended on a Friday, and it could have been refiled, but that was not raised. It wasn't raised at argument. It wasn't raised in his papers, and we would assert that it was waived. And then finally, with respect to standing, there is only one position now that Mr. Newell and I are both district leaders too. It's now Assembly District Leader. There's no female or male district leader, so Ms. Paez did have standing to challenge the candidate that she was challenging. Thank you.
Thank you very much. I had one question for you, Mr. Schwartz, about the Coleman matter concerning service. Were you ever able to obtain the transcript from the hearing on that?
I have tried and tried and tried. I think the reporter finally said she was going to get it to me today. I said the Appellate Division wants it, the Appellate Division wants it. Yeah. She said so does you and everybody else that has an election case. And
So
I will upload it as soon as.
No, I just want to know if you had it as of oral argument.
When I was served with the Mr. Newell.
I know there are good reasons that you might not have it. I just wanted to make sure that you did not have it, and that I missed
None of us have it. When we got the notice of entry, it was just the cover sheet said, as per my decision on the record.
Right. So just to confirm, you don't have the transcript as of today?
No.
Okay. Thank you very much. Thank you both.